This is certainly the question that's going to be defining the next era of global politics. Precedent in international relations works very differently from legal precedent in a courtroom. It's not binding, but it's enormously influential. When a powerful state, for example, acts and faces no meaningful consequences, it sends the signal to every other government on earth. The rules are optional if you have enough power to ignore them. And so what this becomes is, this translates into an arms race. This translates into a cutthroat international environment that is not conducive to the well-being of humanity and the promotion of shared goals as such. So we're already seeing states draw their own conclusions. Smaller and mid-sized powers like Pakistan really are watching what's happening very carefully. The US can strike a sovereign country's nuclear program on the basis of a threat it defines unilaterally. If it can do that, then what stops other regional powers from making the same calculations? Pakistan, India, Saudi Arabia, Iran, Israel, Lebanon. We've seen all of these situations that are like a powder keg, right? And the Israel-Lebanon situation has certainly been there. India started attacking Pakistan. We've seen 2 attacks in the last several years. And really the logic of preventive force becomes far easier to invoke once the norm against it has been visibly eroded by the world's most powerful military. The world has accepted US exceptionalism for quite some time. So there's always that. Now the deeper danger is, this gradual shift away from a rules-based order. However imperfect this order has been, it's better than, say, a power-based or a law of the jungle or a might is right type of order. And so that's something that is deeply concerning. The institutions that were built after 1945, after the Second World War, were never perfect. The Security Council veto always privileged the powerful, but the charter framework at least created like a shared reference point, a common language of acceptability, legitimacy, and general approval by the community of nations, the community of countries in the world. What we're witnessing now may be, the unraveling of that framework and really an acceleration of that unraveling. It had been unraveling for quite some time. Not through a single dramatic moment, but through the accumulation of different cases where, the rules were broken and the world kept on moving on. More rules were broken. The world didn't stop to fix those. It just accepted those and moved on. And so we're not seeing a lot of healing of the international order. We're just seeing different actors breaking it in different ways. And that ultimately leads to a collapse. And so I think that's perhaps the most consequential long-term legacy of these events, that after Ukraine, we saw Gaza. After Gaza, we saw, the 2025 June strikes on Iran. Then we saw these strikes currently that are happening on Iran. And we're seeing, a number of other flashpoints across the globe. So I really feel it's going to be an acceleration of a number of these issues and ultimately, a breakdown of the rules-based order, which would be a very unfortunate and very uncertain, dangerous place to be in. This is really the heart of the matter, if you will, and it exposes what international lawyers call the structural flaw in the international legal system, and that is the enforcement gap. Really, how do you enforce the rules on the mighty and powerful? In theory, there are several mechanisms. The UN Security Council, that is your primary body that deals with international peace and security. And so that, technically speaking, is authorized to deal with this thing. But the problem is, the US is on the Security Council and the US carries a veto. So even if all the other countries, combined to take collective action against the US here, the US could simply veto it. And so that gridlock would be there as it currently is in the UN Security Council. You can have the International Court of Justice take up a case, and rule on state responsibility or the illegality of US actions here and its violation of the UN Charter. But again, the enforcement mechanism, if a state doesn't voluntarily comply, is through the UN Security Council, even for ICJ decisions. And again, we fall into the same trap where the US can easily veto this. You can, if for subsequent crimes, if the US is committing war crimes, the International Court of Justice could take up a case if the prosecutor feels that it's necessary, especially in cases where a member state of the ICC has been attacked. So if attacks take place on their territory, if war crimes take place on their territory by US forces, then US forces could be held accountable. The problem is that the US has already sanctioned ICC judges, and they've also they have something under U.S. domestic law, which is one of my favorite laws that's ever been passed, is the Hague Invasion Act, which basically states that if any U.S. military personnel or any U.S. citizen is held in the International Criminal Court, that the U.S. government is obligated to invade The Hague in the Netherlands and rescue that individual to prevent the ICC from having a trial of that individual. So they've got that going as well. You can also technically have the General Assembly pass a resolution. There are a number of issues. It's morally binding, not legally binding, so it really doesn't have that. States can impose sanctions, and in theory, universal jurisdiction could apply, where states, there are some countries that have their legal system allows for the trial of criminals who have committed crimes in other jurisdictions or in other countries abroad. And so these individuals, even if they're not citizens, depending on the severity of the crime, the type of crime that it is, those crimes could be tried, especially international crimes like war crimes or crimes against humanity, genocide. These types of crimes could be then tried within that country. Now, again, that's a huge diplomatic risk, political risk that any country would be taking. So in practice, when it comes, when the state in question is the United States, a permanent member of the Security Council with a veto, most of these mechanisms, they're going to collapse immediately. And even though we've seen, Russia and China condemn the strikes, they haven't really taken any real action beyond that. And, any Security Council resolution authorizing response would be vetoed immediately by Washington. And so that's the paralysis there. So the main body that deals with these issues is paralyzed. What remains, is your General Assembly resolution. It carries moral weight, doesn't really have any legal enforcement. There could be economic pressure or sanctions from allies, but the U.S. is often the biggest trading partner of most countries that deal with it. So that is a serious concern. I mean, knowing how vindictive the U.S. administration, the current U.S. administration is, I don't think they're going to take that lightly, and they certainly have a lot more levers to pull on many other countries than the other way around. There's always long-term reputational damage, and that's something that definitely will impact the U.S. The U.S. is proving to be an unreliable partner, an irrational actor. Really, it went into this in a very harsh way. It is a country that the Russians call unable to really abide by their agreements that they have. So even the JCPOA that they had with Iran previously, Trump tore that up. It was a U.S. government, U.S. state-backed agreement, and another administration comes in and just pulls out of it, despite its massive success. So I think it's problematic there. What's worthy of note really is that it's not just the international legal system that's under stress because of the decision by Donald Trump and his administration. Trump even bypassed his own Congress because he didn't declare war, but he launched this for this conflict, this war, without congressional approval. And we know that, it's only Congress under the U.S. Constitution that can declare war. So there's no authorization for the use of force, really that way. Now, even previous administrations, they've gained some form of authorization from Congress, whether it was going into the Gulf or it was Afghanistan, Iraq, any of these things. So really the accountability gap isn't really just international, it's also, constitutional within the U.S., and it's also a domestic legal issue as well. The legal position is pretty clear. The illegality of U.S. Israeli strikes on Iran is pretty clear. Look, you have a fundamental principle of the UN Charter, the cornerstone really of the UN Charter is Article 2.4, which is this blanket ban on the use of force, on the use of military force against another state. It's the cornerstone of the entire post-Second World War international order. And essentially, the language that it uses that prohibits member states from using force against the territorial integrity or political independence of another state. And so that's pretty, comprehensive in that regard. And there are only two exceptions here. The first is self-defense under Article 51. So if a state attacks you, a state is committing a crime of aggression against you, then in self-defense you are allowed, and that too, only to the extent that it thwarts the attack on you, you're allowed to use force in that defense. And the second is, actions authorized by the UN Security Council. Now, interestingly, Washington did not go to the Security Council, even though, its own allies, France, for example, said that this is something that should have been debated at the Security Council, and authorization should have been sought in this way. Now, that hasn't been the case. The U.S. struck Iran's nuclear facilities last year. You remember those bunker buster missiles over Fordo and a number of other locations with the Israelis, and that was done without Security Council authorization. And then now, in February of this year, February 20th, just a few weeks ago, the U.S. launched the attack that is ongoing, and that's been far more devastating. It's a joint attack with Israel. It killed Iran's supreme leader Khamenei and targeted government buildings, military sites, oil infrastructure, schools and hospitals. In Venezuela, the U.S. forces they seized a sitting president, President Maduro. Now, none of this was authorized by the Security Council. None of this was sanctioned by international law as such. So, Washington's likely legal argument rests on preventive, or what we call, anticipatory self-defense. The idea that Iran's nuclear program posed an imminent and existential threat, if you will. The Trump administration also pointed to, alleged Iranian plans to strike U.S. targets on American soil. Here's the problem. International law sets a very high standard for anticipatory self-defense. The threat must be instant, overwhelming, and leave no real choice to the state. It has to basically use force to defend itself under the circumstances. Now, a nuclear program that even American intelligence agencies say is, a decade away or several years away, and to couple that with, having the ability to deliver that, having an intercontinental ballistic missile that can deliver this to the U.S., that is, many, many years away. It is not imminent, and it is not overwhelming at all. And secondly, there's no credible evidence of an imminent Iranian attack that's ever been made public. In fact, we're hearing the opposite, that the U.S. intelligence community said that, Iran did not plan to attack the U.S. In fact, Iran was in the middle of negotiations with the U.S., and it is this perfidy, really, that the U.S. has been involved in, that it lured Iran into negotiations and then struck them. And this is not the first time. The same thing happened in June last year, where they were in the midst of negotiations and an attack happened. So what we're seeing is that the legal justification, in the eyes of most international lawyers, most experts in this area, is very, very weak for the U.S.